It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And we have a really juicy episode for you guys today. We have brand new contract information, new UFC contract information. You can only get it here. But before we start into our show, let's go ahead and check in with John and see how his week has been.
Fairly good. Just, before the show, had a coughing fit. So hopefully people out there do not start coughing during the show. But other than that, doing fine.
Good. I'm glad to hear that. I'm doing pretty good myself. You know, I need to remind everyone out there that we want to do a Q&A and ask me anything, if you will, but about business stuff that you might want to know about combat sports. So we want to put it out Thanksgiving weekend. So please send us your questions. You can do it on Twitter. You can do it on Blue Sky. Wherever you see us, send us your questions. And one more point of business before we start in with the episode. We want to thank everyone out there that is listening and absorbing our content. We appreciate you guys so much. But if we could make a small request, a courtesy, if you will, and that is if you do take our content and you spread it around, which we love, please give us a citation. Please mention us, mention our Substack, especially mention our Substack. Because when you take our content and you disseminate it on your socials and you don't cite us, there's no reason for anybody to come back to our Substack where you got your information from. So please, if you would, do us this solid and help us out by giving us a citation. We appreciate all of you. Thank you so much. Now, without any further ado, we are going to jump into the episode. And before we get into those UFC contracts, we're going to talk about Mark Hunt for a second, because he is arguing his own case against the UFC in court currently. So, John, what happened there, and did we get a ruling?
Well, we had a previous ruling, and Mark Hunt appealed to it to the Ninth Circuit, and today they gave him a chance to make an oral argument in front of the court. And so he made his oral argument today by remote, and it was him. The case, remember, is not just him. It's the UFC, Zuffa, and Brock Lesnar are both the defendants. And so that's what happened today. Now, it was interesting if you watched. One, I got to give Hunt a lot of credit because the material he filed obviously had an impact on the judges, right? So he is filing for fraud, for battery, unjust enrichment, multiple things. And during the case, you could tell during the hearings, the judges of the 3-judge panel was quizzing him and the defendants that a lot of his arguments found purchase. It sounded like, you never know for sure because judges, they don't give away how they're going to rule, and you shouldn't over-interpret the way they question people because they might just be looking for a straw man or, checking holes and stuff. But it did seem like they had taken on some of his arguments because they really grilled the UFC and Lesnar about Lesnar, the way his exemption worked. They seem to find it suspicious the way that one of them judges phrased it, made it sound very suspicious. They also grilled Lesnar's attorney about Hunt approving to fight someone who was abusing PEDs when specifically Hunt said that he wanted the person to be tested, and they went back and forth on that. And where the Lesnar's attorney said he agreed to fight someone with PEDs, and they said no, he didn't. He agreed to fight someone tested because it sounded like he did not want to fight someone on PEDs. So that part was pretty interesting. It's hard to say how it's going to go. We're going to have to wait and see, but it's just based on what happened today. It's also hard to see how Hunt is going to win this case for one simple thing. They brought up repeatedly the damages he suffered. And that's where he didn't really have a good answer. What kind of damages? And when I mean damages, like what monetary damages did he suffer by losing to Lesnar? Right. So he started to answer at one point that he was ranked number 5 in the world when he fought Lesnar, and his progress up the extension up the ranks was stymied because of that. It stalled. And I thought that was a kind of a direction to go, but he kind of abandoned it. And, he's not a lawyer. He hasn't done this a lot. So you got to give him some, break for his answer. But I didn't hear a strong answer what the damages were. And the problem is the UFC and Lesnar brought up, he had a 6-fight guaranteed contract that he signed at UFC 200 that went up $50,000 per bout, win or loss, and he fought out all 6 of those fights. So it didn't seem like monetarily he suffered from that loss. So that's the one part, because that's a key component to his argument. Did he suffer damages?
How would you have argued that for him as far as the escalator that they talked about and everything? How would you have helped him prepare for that?
Well, I am not a lawyer, so that's the first thing I'd say. Go get someone smarter than me, someone that knows the law better. But I think from my point of view as a layman, just someone that talks to attorneys and just rips off everything they say and just repurposes it for myself, because thankfully they do not want their name drop. So I get to get this free content that I take from them and claim it as my own. I think one problem he has is that it's being sport is different than just a regular business transaction, because in sport, you are looking to improve your status, improve your prestige, to get a result that you want to win. And there's no actual financial money to that. In other words, when you go compete, athletes compete, sometimes they just want to prove they're the best in the world, right? Or show that they're better than this guy. And how do you put a financial value to that if we don't know, if we can't in a but-for world say this is the money you would have made if you would have won that match or if you won this prize. And so, I mean, I think because he is in a contract at the time that paid him no matter what, it's very hard for him to make this argument that in a but-for world I would have made more. But I would have tried probably to bring up that if I'd won this match, I would have had a chance to win for the title. And this is what we're in this for, the sport, to win the title. And with the title, potential to win a title becomes all these other potential prizes. Now, that might not work because they're going to say, well, there's no guaranteed you would have got the title fight. There's no guaranteed you would have got these bonuses if you won and got, or even, if you would, there's no guarantee you would have won the title. There's no guarantee you would even got a title shot. But that's kind of the argument I think you'd almost have to make. Easier. Now, if he was a different fighter, if he had a different contract that went up tremendously with a win, that had a win bonus, that went up, escalated with a win, and then had pay-per-view points attached with title shot, all those things, then he could probably make the argument about the damages easier. But I mean, his basic point is, which the judges kind of agreed with, is that, him as competing, he does not want to face off against someone taking PEDs. And the UFC's defendant, I think, made a very strong argument because they brought up he didn't suffer damages, but also they argued, basically USADA is the one doing the testing, right? And so he has to show that the UFC intentionally made it that Lesnar could get around those tests or hid the tests, and that's almost impossible to prove. The stronger argument, and I think just based on my gut feeling, is I think the UFC is not going to lose this case. I think it's very unlikely they will, based on, like I said, the burden of proof and the proving damages. The Lesnar part of it, Lesnar, I think there is a chance, based on the judge's reaction, that the judge might grant the appeal for the Lesnar portion of the case, because for Lesnar, where the UFC has to claim, hey, we have no control over the athletes, we were just putting in place a testing procedure. Lesnar is the one that violated the rule. And so Lesnar is the one that's much more susceptible to the idea of battery, because it's like you cheated intentionally and did something that Hunt wanted you not to do, because he agreed to fight you, but he agreed to fight you on the basis that he thought you would not be abusing PEDs. But still, it's going to be the damage part. It's going to be really hard to get over, I think, to get past that.
One last question on this before we move into our next section. And that is, was he able to, like in discovery, was he able to use anything from the antitrust case? I'm unfamiliar, so this would be your purview.
Well, I've tried to go through the case. And I can't remember. I couldn't recall. I asked other people who've been following the case and no one could recall. And I do not know if they submitted like the class cert from the antitrust case, but I think that would have been a good thing to bring up or to point out about the antitrust case, because they're like, Hunt did not, he agreed to do this fight on his own, and you could point to the antitrust case and say, listen, I have to take this fight. When you say I don't have to take this fight, that's not true. As the judge certifying the class action, as he pointed out, there's all these coercive methods the UFC has. So I can't just turn down a fight because I think because I don't want to fight him, because the UFC could potentially punish me for that, right? So I did not see that. I didn't see it brought up in this. I might have missed it. Now, to be fair, I might have missed it. This went, kind of quick, and Hunt couldn't fully hear him all the time. So maybe they brought something along those lines, but I didn't see it. I didn't see it submitted. I will note that the UFC, the attorney for the UFC, I thought he said something that's a falsehood.
Oh, what was
during it? And what he said is he was asked a question and he replied that the UFC has no control over what USADA does, right? The USADA does it completely independent. And that's not true. Remember, the UFC, they wrote the contract with USADA for that. And the UFC is the one that had the loophole inserted where if you come back to the UFC, you don't have to take the test right away.
Mm-hmm.
You don't have to wait the 6 months. The UFC was given the right for that waivers for him. So him to say that the UFC has no control over it did not seem accurate in my book. So I do not know if that's going to be highlighted to the court, if the court's going to pick up on that or not. But that's the one thing, several things caught my attention, but that really caught my attention, that did not seem accurate what the attorney was saying.
Any final thoughts on Mark Hunt's case before we wrap this section?
Just that I think a lot of people ridiculed him for the case. And there's certain parts I will kind of ridicule. He, on Twitter, he talks about a RICO Act, and I don't, it's not being discussed here, and all these other things and how it's going to change the business. Even though he verbally said he was willing to fight, Lesnar at all times, as the judge says, that's bravado, that's fighter bravado. The crux of the case that'd be interesting to know is if a fighter wants a clean sport, and I'm putting that in air quotes, clean, the question is, do we want the promoter then to have such carve-outs that it's basically impossible to guarantee kind of a fair playing field for all fighters? Because that's where I think his case had a lot of strength. It's one thing. I do think the promoter has no way of controlling every fighter. He can't guarantee everybody's going to be clean, right? He just can't. The fighters have to go in knowing there's a chance their opponent is going to be abusing something they think is illegal. There's just no way to guarantee that. But does the UFC as a promoter, are they able to take actions that make it much more likely that fighter will enter the ring without following the same rules that everybody else that would make you assume that they're clean? I had a question. I wish Hunt had brought it up, but we know, as the UFC said, John Jones tested 3 days before and we yanked him. And their argument was, see, that shows we'll yank anybody. And I think Hunt should have brought back, yeah, that just made it more likely they're going to keep Lesnar, because who else are they advertising on the card? Now you're down to one star on the card instead of the two, right? Mm-hmm. That's one. But the other part is, if you could test John Jones in that time and have a period where right before the fight you would know on the most recent test, could he appear in the event? Then why wouldn't you ask USADA to say, hey, what's the most rapid result we can get back in time?
Because they knew, right? Well, it appears that way.
I wouldn't say they didn't. You can't say the UFC knew, because the whole point is USADA's doing the testing and they're not getting the results. But I think the argument is the UFC would have the idea that potentially there could be a failure, mm-hmm. and we don't want to know.
Yeah. Until
later. And so I think that's the argument he's trying to make. And I think that's a strong argument, but I just doubt it's going to work, because again, there's no damages involved in the case that he can point to. At least there might be some submitted material the court will see and say, these are the damages. But today and during the hearing, he didn't present damages that were convincing to, I think, people listening.
Okay. All right. So we are going to move into those contracts we talked about. Let me just say something real quick, because behind the scenes, John gets confidential information all the time. But where he really, really shines is that fighters and managers trust him so much that they give him copies of their contracts. And that is how we're able to provide information like this when nobody else can. So once again, John has gotten contract information and it's brand spanking new. So my first question to you is, what are we going to be looking at today?
Well, we're going to be discussing 3 sections of the UFC contracts that look like they've changed. Earlier this year, we did an episode about UFC contracts, right? And the new contracts, and no surprise, they weren't that good. The new changes compared to what they were in the past. And so we're going to talk about 3 additional changes now to the contracts we've seen. I've seen them in several different contracts. We try not to report on them if it's in one contract, because you can kind of give away what fighter you got from PCLD 1, right? Mm-hmm. So we get several, and we can say, okay, this is the new standard to the UFC contracts.
What about the sections? Where are we seeing the changes? Which sections are they?
Well, we're going to do the 3 sections we're going to talk about today is the terms. And basically, we are going to talk about the sunset clause in the terms, right? That's the one I think we've talked the most about the last few years.
But how about for new listeners?
Well, yes, for new listeners, we're going to go through the sunset contract terms, and there's 2 of them, 2 different versions of that they have, which is interesting enough. We are also going to talk about the injury and retirement section, because that's different than what it was before. And then finally, we're going to talk about the right of first negotiation and right to match. So those are 3 different sections of the contract that are in all UFC contracts. And those 3 is where you see these changes.
And to clarify, you've received multiples from all different levels of fighters of these newer ones, right?
Yes, these are coming from. I'm going to read that. We're going to have the terms are going to be the same, but they're the same in multiple contracts. In fact, I am pretty confident these are the standards now that basically all fighters will have in their contract if they've gotten a new contract over the last, let's say, 6 months or so.
Starting with the earliest ones, what were the changes to the sunset clause in the terms? And also, for the new listeners out there, explain what a sunset clause is.
Well, they don't call it a sunset clause, but technically a sunset clause in a contract is the time period the contract ends. It's a definitive date that it ends. The UFC, they use the term termination date for it, but a simpler term that a lot of people more commonly use is called a sunset clause. And the reason is this is the period when the contract sunsets, it ends. You can't go beyond no matter what, basically that term. And if people remember to go through it, the UFC in the past had no sunset clause. So what that is, if I sign a fight, a 6-fight agreement for 25 months, let's say, that's used to be kind of an old standard. It starts the date I have my first fight, or I sign the contract, one of the 2. And then after that first fight, then over the next 25 months, they have to give me the remaining 5 fights. So that's the period how it works. And over that time, if I turn down a fight or I can't accept a fight for whatever reason, or I'm injured, they can extend the contract 6 months or so, right? Extending the terms. A sunset clause would say, even if I miss fights, even if I turn down fights, at a certain point, that contract's going to end no matter what, even if there's fights remaining on the contract. But in the old contracts before 2017, there was no sunset. So those contracts could theoretically go forever. So, for example, Nick Diaz, he would have him as an example was under contract for like 7 years, a ridiculous amount of time, disappeared, showed up, and he still had fights left years after he'd quit fighting. 2017, though, because of the antitrust lawsuit, because that was one of the things they're highlighting is these contracts could last forever. The UFC introduced changes. And one of the changes they introduced was a sunset clause, the termination date of 5 years after you sign the contract. Now, years later, someone took advantage of that. Mm-hmm. And that someone was Francis Ngannou, right? And he left the UFC because he had a 5-year sunset. Otherwise, even though he finished his 8 fights, he still had the championship clause in place, and that all those extensions, turning down fights, would have continued. So he would have been stuck in the UFC longer if he didn't have that sunset. And so lo and behold, after Francis leaves, what do? Well, they have a class action waiver and arbitration agreement thrown in. So you can't, take this to court. You can't use this in the class. You can't be part of the class action. So interesting enough, now they've changed the contract again, but they have 2 different versions. They have 2 different versions for basically 2 different levels of UFC fighter. They have one for the beginning prelim type fighter, and then one for the higher ranked contenders, the better fighter. Now there might be a third version. I've heard someone mention a third version, but I never got my hands on a contract that had a third version of somewhere in between. But we have 2 different versions of this termination date that is different than what it was before, and we are going to go look at this now, and then we will discuss why there's 2 versions.
To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!